Welcome, everybody, to Legal Tech Week for July 24th, 2020. I am Bob Ambrogi. I write the Law Sites blog, host the Law Next podcast, and do various other things, I think. And we got a little bit smaller panel this week. But Caroline Hill is off for celebrating her birthday, and Victor Lee wasn't able to. I think he's taking some time off from work. So who we do have this week is Molly McDonough. Molly, you want to introduce yourself?
Sure. Molly McDonough. I'm a media strategist and legal affairs journalist based in the Chicago area.
And Nikki Black.
I am.
You're just waving to us. You're not going to talk this week?
All right, that'll be the day. My name is Nikki Black. I am an attorney and a legal technology evangelist with my case, and I like to say I exist where law and technology intersect, and I love to write and speak about tech. I have legal tech columns on ABA Journal, Above the Law. I write for the Daily Record. I also write for the My Case blog and other outlets.
And Victoria Hudgens.
Hi, everybody. My name is Victoria Hudgens. I'm a reporter for Legal Tech News, where I cover cybersecurity and the intersection of technology and the law.
Joe Patrice.
Hey, Joe Patrice, Above the Law. I'm in a different room, so you don't get to see my yellow dinosaur that people have commented on this week because they're drilling a giant hole in my front yard. So that's exciting.
and that is for what? We don't want to know, right?
Yeah. The authorities have no need to know. No, it is a kind of techie. It's gonna be a geothermal heating and cooling system. So it's gonna be nice. Super.
And Zach Warren and his little friend.
Yeah, I decided to take over the yellow dinosaur that happened to be within arm's reach of me. Actually, completely coincidentally. Hey, everybody, I'm Zach Warren, editor-in-chief of Legal Tech News, part of ALM. I work with Victoria, and we are part of the ALM network, so my stuff is also on the American Lawyer, Corporate Counsel, etc. And I will put this stuffed animal down now.
All right. Where should we start this week? I kind of feel like starting with this news of the new Thomson Reuters news service, which I wrote about. Once again, some of these stories just strike me as strange. Not so much the news isn't strange, but the way they come about is strange because, what the news was the Thomson Reuters introduced a new legal news service this week that they're calling Westlaw Today. But they did it in stealth mode, which is just so strange for, I know a lot of you folks on this panel know that usually when West rolls something out, they roll it out. I mean, in the old days, even they would fly us all out to Egan or something just to see it and get a preview. And this just kind of happened with no announcement whatsoever. And I'd been kind of hearing rumors for a while that they were possibly starting something to compete with Law 360 from LexisNexis. And they've been advertising a whole bunch of editorial job openings. And I kind of asked several Thomson Reuters executives over the last week about it and got lots of no answers or don't ask me, ask somebody else. And then finally, earlier this week, I got a call from one of their PR people who said, let me look into it. I don't know anything about this, which is bullshit. And then after my call, then they launched this thing. And then they call me and say, yeah, by the way, we've just launched this thing. That must be what you're asking about. So I don't know. But it's interesting. And I do think there's still more to come here. I don't know. Zach, you're out there in their neck of the woods. Have you been sneaking around their headquarters?
I have not been sneaking around their headquarters, no. With my LTN hat on, I agree with you that I think that there is more to come because especially the features that you detailed in your piece seem to be pretty commiserate with what they had previously. It didn't seem like they were promising upgrades, but there wasn't too much tangible. It seemed like there needs to be something greater there, which might be why they had the stealth release, just looking to build up a little bit of an audience and a little bit of awareness before something larger. Taking off the LTN hat, You may notice that on the website they had a quote from Lee Jones, who until a couple weeks ago was the editor-in-chief of ALMslaw.com. She is also not the only person I know that has been recently hired by Thomson Reuters. I don't want to go further down that path because anything would be speculation, but that says something.
I did not even notice that. I noticed a quote from Lee Jones, and I said, "Oh, yeah, Lee Jones. I know her," but I didn't make that quote. Yeah. I knew the name, but I didn't associate her with law.com. But yeah, that's interesting. I mean, I've talked to some other people who have applied for jobs there, and then they all tell me that they had to sign NDAs or something, and so once they've applied, they can't. So interesting.
Well, if nothing else, at least there's going to be another outlet to cover the legal industry, since some of the more traditional ones, the newspapers and whatnot, had struggled. So at least we're going to have some other outlets covering it now, since all these niche publications in all different areas are having a hard time. So I think from the perspective of the viewer or the reader, seems great to me.
Yeah, no, I can't complain about another news service launching in some way. I'm curious how this will formulate, especially, I mean, Thomson Reuters has been in news for many, many years. And even when it was Thomson, they own newspapers. I worked for Thomson Chains before. So it's interesting to see kind of how they've morphed and what they're going to do differently from Reuters, and how they're going to use this as a news service for just legal, and what they're going to focus on, which we don't know, although we've all seen the positions and know about people applying.
Yeah. I agree with you, Nikki and Molly. Great to have another news service, but it's going to be another news service behind a firewall. I mean, right as of right now, it's available only to Westlaw subscribers. Maybe they'll extend it beyond that, maybe make it something like Law 360, but it's still, I'm sure, going to be just to fund all this talent that they're hiring. I'm sure it's going to continue to be a paid and probably a pricey paid subscription in order to get access to it.
Well, Law 360 is a really, yes, we know, but Law 360 has a really pricey paywall too.
Yeah,
and they only have a very small fraction of their content that's available without a paywall,
right.
And they're so expensive. Like as a small business, I was trying to get quotes just as an individual, and it's just prohibitively too expensive for me to subscribe to it right now.
Yeah. And it's too bad, because they do a really good job. They've got some good reporters. They've got real sort of like boots on the ground coverage in a lot of courts in a lot of cities, and doing some good stuff. What else?
This is why I tell everybody, though, Joe, to go to Above the Law, because you don't have a paywall.
Right.
We read Law 360, so you don't have to, kind of. But no, we view our business model as being very supportive of the paywall services, in that we're kind of like clownfish around the big animal, that we read them, we make a few jokes, a spoonful of sugar those stories, and then hopefully drive people back and be willing to brave the paywall to read the full story. That's our life mission.
I will forever now see you as a clownfish every time I talk to you. Whatever a clownfish is.
You didn't? I've been using this analogy for a while.
So my the way I used to get all of this news years and years ago was subscribing through Thomson Reuters, through Westlaw, and doing news searches and setting up news alerts, and then I got everybody. So yeah. I haven't seen a good service like that pop up yet.
Yeah. So let's see. Who wants to go next? Volunteers? Molly, you had a bunch of stuff going on. Or go ahead, Joe. Go ahead, Joe. Joe started to talk. Let Joe go.
Okay, go ahead.
Well, I think they're all. I think we have a lot of semi-related stories.
Yeah,
today.
we do.
We have a lot of stories that all deal in some way with the ways in which moving court processes online raises issues. I mean, I think a lot of us knew that there are reasons why we can't wait forever to bring back courts, and that some sort of a virtual solution was necessary. Among the many reasons the Constitution says you have to get a speedy trial. But there were reasons we had to move online. But as we've done that, a lot of people have started raising concerns. And among them are, I mean, we had I think we may have even discussed this one before, but there's some concerns about grand jury testimony being kind of done by Wi-Fi. But now we also have a discussion, and I think maybe before we talk about my funny story, we should go to the story about some of the states that, the states that have logged a bunch of hours already and what they've dealt with, and B, the group that is pointing to some of the issues that are coming up with this. So one or the other of those, I think, should probably go first.
Yeah,
and then funny story.
I was just going to say that there's not too much to say about the first one I said, which is the first one I pitched out, which was the 500,000 hours for Michigan courts on Zoom. It's just this enormous amount of time for judges and litigants and anyone coming before the court to be on video conferencing. And I think that segues into the other 4 stories that you guys all raised about ethics and procedure and due process that are all popping up and really important concerns.
Yeah, I mean, one of those things that was this report. I did write about it on my blog from this organization called STOP, which stands for Surveillance Technology Oversight Project. And I thought it was interesting just because I think in some ways we are all so in awe of this shiny new object of online courts in a lot of ways, and I think a lot of people aren't stopping to really think about some of the security concerns and privacy concerns and due process concerns that these courts can raise. I mean, I will say, I know that Richard Susskind in his book on online courts actually has a whole big part of it about all the potential downsides of online courts, and he does talk through a lot of these issues. But this one just raised just a number of interesting things. Some of it is just access, the fact that there are a lot of people who just don't have great internet access or aren't comfortable with this technology, and who can be disadvantaged by being either a litigant or a witness trying to testify or otherwise participate in a hearing online. I thought some of the points that this report raised around lawyer-client communications were interesting. A lot of courts that are using Zoom breakout rooms as ways for attorneys to consult privately with their clients. This report points out that you may not know exactly what's happening with that breakout room because the host who sets up the Zoom meeting is the one who controls that breakout room. Are they secretly recording you? Are they somehow making a record of this? You as a lawyer certainly should exercise some due diligence around the security of these things before you meet with your client, which then goes back to another favorite topic of mine, which is the whole duty of technology competence and the competence of lawyers to do with that stuff. But you can read the full report on my blog, but it certainly raises a number of issues. And Joe, I know you had kind of a more specific example of one of those on your blog this week.
Yeah, no, definitely. But before I get to that, I will say of a lot of that report, when I read it, I thought a lot of the issues that they raise are important and obviously worth considering, but it really hit me. What I took away from it was that there seems to be something of a blind spot that the whole profession has for the ways in which the court system is already inaccessible, right? Like people were saying oh, the digital divide, they may not be able to have this. And I was like, do you think it works right now for somebody who's working a job to leave their job and come down to a court and go through a weird metal detector and screening process? Like our courts are designed to be off-putting to people who aren't in the club, basically, already. Pro se litigants talk about this all the time. And obviously there are litigants that I call prosane, but but the less insane litigants have this problem all the time. And it's it's interesting how we kind of close down that obviously being in person is totally fine. It's just when we move online that there's all these blockades and seems off-putting to the public. But whatever. That was my takeaway from it. I don't know if anybody else thought something similar. What we wrote about this week, though, was an issue that is very much concern with how one of these digital meetings gets conducted. And in Kentucky, a judge used the mute button, which I'm sure at some point Bob will use on any one of us, but because the host can use the mute button to stop people from talking. And the judge did not want to hear anything from the defense attorney and kept using it for minutes on end. And the question is, the defense attorney has now filed to complain about this and get the judge recused from the case. But to what extent, though? I'm taking a bit of a devil's advocate side. This story seems pretty egregious, but taking a bit of a devil's advocate side, you do have to manage these conversations. And if you have two very zealously advocating parties, they will yell at each other. And in person, you can kind of bark over that. But in tech, it's hard. And so where is that, finding that line between what is good management by use of the technology and what is prejudicing the client by shutting up their advocate is something that we're going to have to spend some time working out while we're doing this.
Well, the Supreme Court figured it out with times. So you have your time allotment, so you have your turn, you have your, I think it's possible. I agree that this one, you did a nice job with this one, pointing out all the ways that this one, this seems not quite right. But you have to be able to take your turn, like even in this format when we all try to defer, it's everybody wants to jump in at a certain point. You have to moderate.
And I did think that one of the complaints that people raised, that some of the experts in the original write-up of this story, which was in the local newspaper in Louisville, one of the concerns that was raised by some of the folks that they quoted was that unlike the Supreme Court, where you have an oral argument that's you go your 10 minutes, then they go their 10 minutes, whatever, in a hearing that's not a motion, like a oral argument on a motion, you have to lodge your objections to what the other side's saying. You have to be able to do that in real time. And so that's why you can't necessarily go on time limits. That said, I thought they were kind of eliding the fact that this was a motion in front of a judge. As long as there's no jury, I don't know as though I worry that a judge can hear whatever they want and then mentally process backwards. They don't need the objections in real time. But that's true. I think anything in front of a judge, you can have time limits that cover it. But once we start having individuals involved, like juries involved and stuff, how do you keep this managed?
I thought it was inexcusable that a judge would do that, even in a hearing. It's one thing for a judge to tell somebody to be quiet and tell somebody, I'm going to hold you in contempt if you don't be quiet, but to not even listen to them and hear what they're saying, that's something that would never happen in an actual physical courtroom, and I just thought it was inexcusable. I was shocked.
What I think is interesting, and we've talked about the lack of professionalism over video calls the past couple of weeks or so. It's been mostly from the attorney standpoint, but I think you're getting a little bit of it from the judge standpoint as well. I think there's still a mental switch that a lot of people haven't necessarily flipped yet of these are business calls. This is a professional setting. We can't necessarily function the same way that we would if we're on a Zoom call with friends on Thursday night or something like that. You need to
completely agree
to a different standard. Yeah. I was actually thinking of grabbing a beer.
I view this as like legal tech happy hour. So I'm
with you on that one. But no, I mean, it's supposed to be functioning as a court proceeding. And every party involved, including the judge, I would think, should be going that way.
Right.
Well, as a former public defender, I'm going to have to take some issue with something you said, Bob, that the judge has to listen to you. I kind of feel like the judge rarely listened to me when I was a public defender. Only certain judges, I won't name any, but there were times when they just wouldn't let you talk. And I actually had one judge threaten to hold me in contempt because he said I rolled my eyes every time he set bail. And for about 10 minutes. I didn't blink. He said he was going to throw me in jail, and I didn't blink for 10 minutes. I don't think I've ever not blinked that long in my life. But with the Zoom stories, though, I don't know if I brought this up last week or not. I don't think I did. I wrote about from my Daily Record article that I submitted last week. Actually, it might have been yesterday. It's hard to recall these days. But I'm just drinking water over here. But hey, but there was a case out of the Southern District of New York where it was about during depositions with Zoom calls, and the judge had to issue an order saying that what the plaintiff's counsel wanted was to be able to record the screen of the deponent while the Zoom call was going on and the deposition was being conducted to prevent any coaching and that type of thing. And the judge said that was just unduly intrusive, and that she wasn't going to require that. But she did set some rules, in terms of what she was ordering them to comply with, and that you're not supposed to coach the witness. And we all know this. But it was interesting, and I'll link to that here. But it was an interesting issue. I mean, there's just all these issues that are coming up that occur in a remote setting where you would be right next to the person and you could tell if they were coaching them, versus in a remote setting, they can be writing notes and handing them over to their client and you'd never know. So that is really incredible, all these different issues that are popping up that you just don't realize would be an issue till you encounter them in this virtual hearing setting.
Right. I thought it was interesting, Molly, one of the stories that you mentioned, I forget whether you already talked about this, I don't think you did, was just that how many hours are getting logged in Zoom hearings right now.
Yeah, no, I kind of just brushed through it because it's just a number out there, but it's an impressive number. And Michigan was already moving in this direction. But they obviously had to move much more quickly than they were anticipating. But they'd already been dealing with big remote areas and trying to be able to serve some of those spaces that are so far flung in Michigan. My son's up in the Upper Peninsula today, and I feel like he's in another country at this point, and with no.
So do people from Michigan.
Right. And it's really hard to get to. He had to get to the Upper Peninsula through Wisconsin. So otherwise, it's maybe best way plane or boat. So so it just seems like an enormous number of hours, but they've been able to keep their courts functioning, which a lot of states haven't been able to do.
Yep. All right. Who else? Victoria, did you have a story this week? I don't think you sent around anything by email in advance, so I wasn't sure what you had.
When I saw the stories that you guys were going to bring up today, I did kind of see, like in New Jersey, one of our ALM sibling publications, they posted about that there's a lot of pushback from the states adopting kind of like a hybrid approach, and like what you guys were mentioning about the problems that can occur when you have jurors that maybe aren't as tech savvy or don't have access to technology. And there's a lot of pushback. It's pushback from the Association of Criminal Defense Lawyers, I think also public defenders. And it's kind of interesting how states will kind of try to handle this situation. Will they bring in people? Will they just continue as life as normal and just have everyone come back in to the courtroom? Or like what New Jersey is trying to do, a hybrid mix of jury trials. I think jury selection will be remote, and then the voir dire process, hopefully I pronounced that phrase correctly, would be in person. And you're hearing a lot of pushback from it. So it'd be interesting to see like what will courts in the United States do. They can't necessarily just say, hey, we're just not gonna have any court proceedings during this time. We have to do something. And with limited kind of budgets you can't necessarily redesign the courtrooms and provide like specific type of airflow. So it'll definitely be interesting to see how that kind of plays out with these states, and how much will kind of like the dockets be a little bit at a standstill. We have to balance health with people's litigation needs.
Right.
Something I thought was interesting.
Yeah. Any thoughts on that?
Go ahead.
Well, just because the public defenders lost their case. It actually did. We were talking last week about how I'd read that they might be bringing a case. They brought the case and it was dismissed. I'm not sure if they're appealing. The New York City public defenders, they wanted to try and avoid in person-to-person court, and they wanted more virtual hearings, but so far they've been unsuccessful in that endeavor. So I just want to throw that.
So that I think I really, if you have a chance to listen to the some of the webinars from the National Center for State Courts and the Conference of Chief Justices, it's been really interesting to see what courts are doing to address the flow and capacity, and like even using empty buildings down the street, putting juries in one room and courts in the court process in another, and setting up all these different flows and keeping everybody else at home as much as possible. So it's really, everybody's doing something a little different, but it's great to see all the sharing, to see what's happening and seeing what's working.
Yeah, I think I read coverage about that. Sorry about that, Zach, but I think Ross Todd, one of my colleagues at ALM, he wrote about that, and he mentioned, one of the judges mentioned, I believe she was in Texas, they were thinking about using the quad that's nearby the courthouse, but she said we have to wait until it's not an ungodly, like it's not so hot as it is in Texas, to go outside and have proceedings. So it does seem like they're trying to be more creative and just kind of like, how can they still, no one said like their caseload is at 100%, but just still keep like, not have like a bottleneck where you just can't, COVID-19 stops you from having any type of jury trials. But I think the judges there, they were just pretty much like, you have to work with us. Things won't be 100%, but we have to make something work.
Yeah, they were. Yeah. So some of them were doing like shuttle services, but then they can't put the bus at full capacity either. Yeah. So they have to run more buses.
Yeah.
If I have a devil's advocate for all this, there's a lot of cool things that individual judges and even individual courts are doing, but it does worry me that there is not coordination on a wider level than that. The fact that individual judges are kind of having to jury-rig these systems to make whatever they can work for their own courtrooms, it doesn't provide the standardization that I think may be necessary for justice to really be achieved in many cases. So it's cool what people are doing. I just wish that there was some system that it could be adopted on a wider scale.
So I will say that's what the National Center for State Courts is doing. So they're in the process, they're producing guidelines, and I think this was a while back, but they're very quickly producing guidelines for chatbots, for managing the reentry process. They've had like 3 programs in a row, and then they publish all their documentation and recommendations for safe reopening. But that's the only place I've seen it really in a coordinated way. But it is the kind of chief justices all working together to try to come up with a system as much as you can with such a localized process.
Yeah, and that goes to, that was actually one of the issues that was addressed in that STOP report we were talking about earlier. I don't think I wrote about that issue on my blog post about it, but that was something that they talked about, was the need for coming out with some, cross-jurisdictional standards for basically for records, for records format and records retention, viewing it as a security issue, but also an access issue, because, this is going to be one of those, this is like, bring your own device to court now, and so we're going to have all these court hearings being recorded or not recorded in all these different formats, and for members of the public who want to get access to this stuff, it's going to be confusing, if not impossible. I know that I think almost every week I talk about this Judge Schlegel down in Louisiana, because he's always doing so many interesting things, but I know he's about to introduce this. I think maybe he's actually already using it. A sort of a real-time Slack channel for the cases. So basically, when a matter comes before him, he tells the lawyer to join his Slack channel, and they have sort of real-time communications about it. I mean, instead of like filing a motion, basically the lawyer like goes onto the Slack channel and says, Judge, I need you to do this or something, and then the other party can respond right there, and the judge can then issue his ruling on the Slack channel. Or I may be
just feels
a little bit.
That feels so Old West, right? Like that feels like you just rolled into Judge Bean's office and told him, we need to go down and get these cattle rustlers.
Those outdoor hearings brought me to like more medieval times. The concept of that reminded me for some reason of Monty Python when they're trying to decide if it's
He's a witch.
Yeah, like are we all just gonna like regress for some reason because of these remote hearings? I don't know.
I will say there's a conversation going on in the chat that I think people are seeing half of, because I think they're only seeing Molly's responses and not the original questions. But there is a federalism issue here where we need unified responses. And unfortunately, in a lot of these jurisdictions, the state legislature runs it in one jurisdiction, the Supreme Court of the state runs it in another, and there's not really an easy way to smooth out those edges. Those of you who've done lobbying work or whatever know that, like in the world where everything's run by legislatures, ALEC can just come in and dictate what all the laws are in all the states, but you can't necessarily do that here.
Right.
Yes, that was one of the things that what you wrote about, Bob, that gave me pause with that report was I think a lot they made all very good points, but I actually am a little concerned about adding too much bureaucracy to this period of innovation right now. I feel like we're making so much progress. I like the guidelines and the collaboration, but I worry about somebody coming in, an entity coming in and saying, "That's it. This is the way we're gonna do it. This is the way we're gonna do it forever." And no matter who it serves.
That's what worries me too, ultimately. And I think having the guidelines are great, but ultimately, if there is progress, it's just the tech person in me that I want the most innovative to stand out and get a serious look. And if you're getting that many people in a room, it worries me that it would go to the lowest common denominator of what would be adopted. So that's just me being a tech person and always wanting to try and push the limit, though. I do realize that.
Yeah, I mean, for me, it's interesting because I do lobby in my day job, and I am often lobbying around issues regarding access to government information, and one of the concerns that even though I'm a techie, in terms of the legal world, often I'm arguing against tech solutions in terms of access to government information, because there is just still this issue of the fact that there are large portions of the population who just do not have good access to the online world. It's getting better and better and better, but there are, even in Massachusetts where I am, there are huge areas of Western Massachusetts where there's just no broadband access. You can't get it. It's just not available still in Massachusetts, and lots of people their only internet access is a mobile phone, and probably an older mobile phone. And a lot of these people are not sophisticated. I spent some time today trying to tell an older relative of mine how to unlock their iPhone, those are real issues. And I think with these, that's what I like about this report is it at least says, let's stop and think about some of this stuff and be cognizant of it as we go forward.
Do any of you guys think that it's that there should maybe be a platform specifically for these types of court proceedings, and not everyone just using like Zoom platform? That's the one thing. Like, I know we kind of had this sudden rush, but it is kind of concerning. Like, you have these series, life and death events, and they're through like a Zoom platform. And I know like they've worked on their encryption and everything like that, but does anyone think that there maybe should be a platform specifically that maybe have the data privacy or cybersecurity or protections built into it for these types of matters or litigation in general?
I think that would be fantastic. Unfortunately, I saw what the federal government did with Pacer, which is a perfectly fine system that costs there are Pentagon programs that blush when they look at what Pacer costs. So I don't know. But yeah, there should be something.
Yeah, I don't know. I mean, I think there should be something, but then you get into this whole, bloatware bureaucracy road of some company trying. I mean, look at the court systems now. Just a lot of the systems that have been competing just to put court records online. some of them are just so horrible and cost so much money, and just, some hacker over a weekend could design a better system than some of these things that are out there being sold commercially. So I don't know how you get around all that. And I do see Valerie Chan saying there are some systems out there that she mentions, the vTestify one, which I've actually written about. I actually, that's a great system for depositions, and it's not for court hearings per se, but it's great for depositions and mediations and that kind of stuff. So there are systems being built as kind of more specialized and custom uses, but I do worry about, it would be great to standardize, if you could standardize on some kind of an open source, something that the courts are going to collaborate on. I
think that's one of the things I like about what Utah is doing with their sandbox, is they're publishing everything, so that others can build on it and improve on it. So I think if there is any one system, that would kind of satisfy Zach's issues too. If you kind of start to move towards a best practice, but then continue your sandbox experimentation and improving, and let everybody else have that opportunity to keep customizing for whatever their needs are. A lot of these are, really different needs, different areas, different geographies too. So, it's not a one size fits all system.
Yeah. Who else? I know, Zach, you had a story you wanted to bring up. You want to talk about that?
Well, we've talked about it a little bit in the past, just the prevalence of data breaches, but I did find it interesting, the ruling in the big Yahoo class action data breach, where the settlement was accepted, but the lawyers' fees were not. And the reasoning that Judge Koh gave in that case was essentially that what the lawyers did wasn't novel. She had previously made a ruling in the Anthem data breach case that what the lawyers were doing was exceptional and they were justified in demanding high fees. But here she said that a lot of the work had pretty much already been done, including in that Anthem case, and they weren't really blazing new ground. So the lawyers were asking for $30 million, and she thought that was too high. So for me, it's just kind of something to watch for with litigators, because these big class action data breaches, as they continue to happen, we're seen as kind of the next frontier, especially for plaintiffs who were expecting big returns on what was happening, and that may not necessarily be the case.
Okay. All right. So given that this is a conversation in front of legal tech reporters, I feel comfortable with this. And the rest of you watching will hear what I mean. The reason Judge Koh says that, she'd already done one case like this and it's not really hard or novel research, is because, as we all know, because we've seen the demos, every single legal research technology begins with, and so we can trace what judges think. Here, let's use an example out of the blue. Lucy Koh. Every single one of those demos is Koh. It is the easiest possible thing to know what she's thinking, because it's every demo that they put into every bit of software.
It's true. That is funny. Sort of like whenever you get the Microsoft demos, they always have the same person with the same last name or something.
Exactly. Yeah. Like, I don't think people who aren't legal tech folks would appreciate how funny that is. But every time I sit down and see a legal tech thing talk about a judge, they're like, oh, and just out of the blue.
So we should make a Mount Rushmore of that.
Yeah.
Enron data for discovery.
Yes.
What else do we have up there? I'm sure we can follow with a few others.
The Enron data. That's so true.
Yeah, but I think that's an interesting story only because not only because of, but just because, I am all for contingency fees. I'm all for lawyers taking cases on contingency fee basis. But in the class action world, these things are just obscene sometimes. I think the article you talked about the fact that she had approved 5 lawyers in the case, and there were 140 lawyers, and there had hardly really, she said, made it sound like there had hardly been much in the way of pretrial discovery or motion practice or anything else in the case. So here they were asking for $35 million or something like that. I think it was in attorney's fees. And that the individuals who the members of the class who were affected by this data breach are all going to get 6 months of account watch or something out of it. They're not going to get anything. So I do feel like it's a system that's just is out of control and needs reform.
Yeah, although I'm the big class action defender around Above the Law, and I'm like, it depends on what the harm is. And with things like data breaches, if you view the harm as just what happened in the first data breach, then they're going to get a bit of 6 months of software, and these lawyers are going to make millions. But if you view what the class action did as make Yahoo care about data breaches going forward and prevent future people from getting screwed, then the lawyers probably do deserve more money than the individuals who were screwed in the first instance. And so balancing that out, and this is the argument I have all the time with the anti-class action people who troll me in my feed. If it depends on what the harm is, but a lot of times the proactive work that private litigation is able to do in a world where we don't have regulators anymore is necessary. In a world where we had regulators who cared about things, we could do this. But now it's up to the class action people, and they got to get paid.
Yeah, I agree.
Go ahead. I was just going to, that's where lawyers have become, just in the current climate in general, whether it is the breaches, the presidency, the different issues that are suddenly people are valuing lawyers because they're really taking a stand in defending our constitutional rights and doing things that matter. So, and I'm with you on the class action. I tend to think that they serve an important purpose. And even though a large number of people only had like $20 worth of damage, at the end of the day, it makes a difference if it makes them stop this, it makes them stop doing these things that screw over the little guy. I don't know. I think it's a good thing.
I'm all for class. I didn't mean to suggest I'm against class actions. I am all for class actions, and both in order to bring recovery to those who've been injured, and as you say, to help dissuade that kind of conduct going forward. But I do feel that there needs to be some more rational way to figure out how to compensate attorneys in these cases, because I don't think it makes sense to me right now.
Maybe Bob Ambrosia gets a percentage of the recovery for every class.
Then now that would be logical. I could go with that. Nikki, you had stories, but we've already talked about them because they weren't your stories.
Right? Yeah, I had one that was yours, Bob, and one that was Joe's, and then I threw mine in when we were talking about yours. So no, I don't have anything else to say. Whew. You guys you're in luck.
All right. Anything else anybody want to talk about? No? Any questions from our audience? No? All right.
Good luck to anybody taking the bar exam.
We can call it a wrap good luck to bar. Who's still doing a physical one? South Carolina.
23 states are doing a physical one.
Oh, wow.
Indiana is going forward with their online one. New York's moving online, but in October. A lot of states are moving online in October. Indiana has an online one beginning on Tuesday, and as of 11 today, the software didn't work. So things are going to go great.
Oh, great. Good. All right. Well, thanks, everybody. And we're going to be back here again next week. I am going to, for anybody in the audience, I think I'm going to try and set this up from now on as a recurring webinar. So you can register once, I think, and then be able to just kind of get a reminder and come back week after week if you want to do that, instead of making you have to remember to register every week. So we'll try and get that set up for next week. Until then, everybody have a great weekend and a great next week. See you around.
Bye, everyone.
Bye, all.
Bye, everybody.